every institution has a head of state, and for law schools, it's the dean. And so to introduce our luncheon speaker, it is appropriate that our head of state, Gary Simson, the dean, who also teaches conflicts of law and therefore is very comfortable in the world of international law, please welcome him, and he will introduce our lunch speaker.
Hi, thanks very much. I'm delighted to see so many people at this event. It's a terrific conference, and we're especially gratified to have the ambassador, Christian Wenaweser, here as our luncheon speaker. He is, as you've probably seen the advertisements, the permanent representative of the Principality of Liechtenstein to the United Nations. He's also president of the International Criminal Court Assembly of State Parties. He served as the permanent representative to the UN since 2002. He has held and holds a number of important intergovernmental positions, in particular in the context of the Assembly of State Parties to the International Criminal Court. He's in charge of the Special Working Group on the crime of aggression, which is mandated to draft proposals on a definition of aggression for the Rome Statute of the ICC. Since March 2003, he's acted as chairman of the ad hoc committee of the General Assembly, negotiating a protocol expanding the scope of the application of the 1994 Convention on the Safety of United Nations and Associated Personnel. Less directly related to some of the stuff he's doing now, although I think a wonderful backdrop, is various areas of education that he has attained. He truly has a Renaissance education, studying filmmaking, French literature, philosophy, Greek literature, Latin literature, and linguistics. So without any more, let me welcome the ambassador to speak. He will speak till about 1:15, and at that point we'll take some questions from the audience.
Thank you very much for your generous introduction, and thank you, Michael, for organizing this and for not allowing me to eat. It's great to be here and to talk about this. At this moment, it's actually a very good moment. We will resume our negotiations in November in The Hague, and it's great to see a lot of people that have been involved in this for many years, and many of them longer than I have. I want to talk about three things to you today. First is what is at stake at the review conference as far as aggression. The second is how would a possible solution perhaps look? And I'm not going to make a proposal, obviously, but perhaps give some ideas and some outlines, the way I see an assessment of how I see the discussion shaping up. And the third is sort of the larger political context as I see it right now. Now, I'm the chairman of the Special Working Group on the Crime of Aggression, so ex officio, in my capacity, I'm in favor of the inclusion of the crime of aggression in the statute. That goes without saying, because otherwise I shouldn't be doing this job, because this is my job. It is often noted, and people have said it today, that aggression already is in the statute. We decided that already in Rome. So what we are doing, what we're supposed to do at the review conference, is to finish the job in Rome and to effectively give the court in practice jurisdiction over the crime of aggression. So the question is not really whether, the question is how. So that's an important point to note. The decision, in a way, is already there. Nevertheless, of course, people change their minds. They do so individually and they do so collectively. So we must have other reasons as well. A big consideration is the success of the review conference that will take place in 2010. we have not advanced very far our discussion on the scope and the agenda of the review conference. But irrespective of that, what is clear is that aggression will play a very central role at the review conference. Perhaps a predominant role, or a role that overshadows everything else, but certainly a very central role. So the outcome of our discussions on aggression will have an important impact on how we assess the review conference. Third point is we are addressing something that is very topical. Nobody will argue that aggression is not one of the most serious crimes under international law, and in fact the statute itself says so. And I think that has been communis opinio for quite a while. Sometimes, however, the argument is put forward that aggression is sort of an old-fashioned crime, or a crime that is not committed anymore, that it was more that belongs to decades that have passed, and that we are now in a period where armed conflicts are usually internal armed conflicts and thus do not entail aggression. I think that is not accurate, and I think the discussion this morning has certainly made that clear. Another important consideration is the incentive for states to ratify, or the universality of the Rome Statute. As you know, the Rome Statute has now 108 states parties, and we are striving for universality. That means for 192 plus perhaps more states. This is often advanced as an argument for including aggression in the statute, because there is a number of states that criticized the decision in Rome to essentially postpone that decision, the decision on jurisdiction. And it is then said that including aggression might lead to a higher number of ratifications. I personally think that this argument is not quite accurate, and at best overrated. There are, of course, those states, there are a lot of Arab states in particular, that have asked for the inclusion of aggression, and most of them are not states parties. But pretty much all of them have other reasons for not ratifying the Rome Statute. They have reasons that would not go away if we include aggression. They lie very often more in the area of crimes against humanity, and that is not a part of the statute that we would change. Also, it is worth keeping in mind that there are also states that have criticized the Rome Statute because it gives a role to the Security Council, any role really to the Security Council, be it Article 16 or be it Article 12. Now, however we will deal with aggression, I think it's quite clear that some kind of role will be given to the Security Council. So for those states, the inclusion of aggression might even constitute an additional disincentive. So in the end, perhaps we sort of break even on that. So I do not think personally that this is a strong argument. What is clear, though, is if the review conference does not adopt provisions on aggression for inclusion in the statute, is that the general perception will be that this is the final word. I think everybody who is in that working group and who has an interest in it from the outside knows that continuing work on aggression after not finding a solution after the review conference is unlikely at best, and quite frankly a bit pointless, or would be. There would be no political momentum, and in some ways there would not be much to discuss, because by the time we convene in 2010 for the review conference, we will have turned pretty much every stone, much to the dismay of Ben Ferenc sometimes. And we will have looked at all aspects of a possible inclusion of aggression in the Rome Statute. So not including it at the review conference, which is where it is on the agenda automatically, as mandated by the Rome Conference, is to my mind tantamount to terminating the discussion. I think that is a big decision to make, and I think that is an important consideration we have to keep in mind. So the burden to deliver, I believe, is not only on those who want the inclusion of the crime in the statute or who favor that. It's also on those who are skeptical and perhaps not in favor of such an inclusion. Because the decision that will be made, they will also be part of, one way or the other. Now, what kind of solution should we aim for? That, of course, is up to the states parties, or actually to the states, because the special working group is open to all states, not only to those who have ratified the statute. Nevertheless, as the chairman of that working group, I must have some thoughts, and I think this is a good moment for offering them. I think it is very important to strive for the strongest possible political support for provisions on the crime of aggression. The debates on aggression in Rome, pre-Rome, post-Rome, have taken place along the well-known fault lines that are defined essentially by the extent to which the Security Council should play a role in determining jurisdiction. These fault lines still exist, as you know. I believe that we have to work towards consensus, but I'm not of the view that every outcome other than full general agreement is necessarily a failure. Many important decisions have been adopted by a vote, including, of course, the Rome Statute itself. So I do not believe that the important thing is necessarily whether some state or states wish to have a decision put to a vote. Much rather, the question is how many and what states can genuinely lend their political support to a proposed solution, which is also an indication, of course, of an ensuing, possibly ensuing ratification process. So this must be a guiding principle in our work. Second, what I would call the best interest of the court. That is a pretty general phrase, and I think we will all agree that everything we do at the review conference should be in the best interest of the court. When it comes to aggression, we may not automatically agree what that exactly means, because you will have some people that may argue and quite honestly argue that the non-inclusion of aggression might be in the best interest of the court. Others will certainly not agree with that, and I do believe, first of all, we have to think more about this, and secondly, that we must never forget this in our deliberations on aggression. I certainly believe that the overall relationship between the court and the Security Council is a very important element in that respect. and I'll come back to that a bit later. Given the general view that the statute is a very solid treaty and that it does not warrant significant changes at the review conference, the court itself has the one court position, the official position of all the organs of the court, that there are no amendments necessary to the Rome Statute. So given that, we should strive to keep the overall balance in the statute as far as the sensitive issues are concerned, and that relationship between the Council and the Court is certainly one of them. As a substantive element of how a solution can look, I certainly believe that we must have a narrow definition of the crime of aggression. I know some speakers this morning advanced some other ideas. And this is also the area on which we have made the most progress over the past few years. I think we are close to an almost general agreement in principle, because an agreement is, of course, always subject to the rule nothing is agreed until everything is agreed. But I think we are close to an almost general agreement on both the question of state act and individual act definition of crime. This is very important progress, and I do believe that this is the only solution that is politically feasible and can gain traction in a ratification process, or even just simply be adopted at the review conference. One aspect that we have not discussed extensively or conclusively is a very central one, and that's the question: can a solution be binding on all states parties? And this brings us to what we have discussed also here already today in the hallways. That's the question of application, or how we apply Article 121, if we apply Article 121.4 or Article 121.5. We have discussed this somewhat in the framework of the special working group, but like I said, not in an exhaustive manner. Of course, in this connection, again, we must look at the role of the Security Council. It is clear that a very strong, dominant, or even exclusive role of the Security Council has extremely limited support among states. So in order to meet the goal of strongest possible political support, we will therefore need to find some middle ground. We have been trying to do that. There have been suggestions. Some of those have been discussed. Most of those have been discussed. And as Bill has mentioned this morning, there is no sea change, let's put it that way, on the question of the role of the Security Council. So we are still struggling with this, and quite frankly, that is, of course, not a surprise. I never expected anything else, because the Special Working Group is a body that is very suitable to deal with technical and legal aspects, and I think we have done so. We've done quite well in that department over the past few years, but the extent to which the role of the Security Council is defined is not in essence a legal question. That is a political question, and we will not solve that in the Special Working Group. Perhaps we can have some alternative options on the table that have some promise, and that perhaps can gain some traction at the review conference itself. To my mind, that means at the same time that the solution adopted at the conference should probably be subject to an individual ratification process, and in the end leave states the choice whether or not to accept jurisdiction of the court over the crime. Now quickly on the big picture, these are considerations that will likely change between now and 2010. But if you look at where the court is today, we are pretty much 6 years after entry into force. We have a number of indictments. We have not had a trial yet. The court is in the news quite regularly these days. And the two main issues, the two main political issues on the discussion are actually closely linked. The first is that the court has so far only investigations and prosecutions or only indictments on situations in Africa. So that is the first point, and on this point there is increasingly criticism, obviously, from African states, but also from some other quarters. And the second issue that makes headlines these days, of course, is the case of the president of Sudan, Mr. Bashir, and the fact that the prosecutor of the International Criminal Court has requested an indictment against him in July. You know that there is the proposal to have a decision by the Security Council to suspend investigations and prosecutions. It's not entirely clear whether that means against Mr. Bashir or also against the other two indicted people or against the process as a whole. That means on all ongoing investigations and prosecutions, but certainly concerning President Bashir. That's a suggestion, a proposal that was made by the African Union, by the Arab League, and also by the Organization of Islamic Countries in July. Now, I do not know whether the Council will do this. And I don't think at this point the states that are on the Council know that themselves. But certainly I would not exclude it. The Council may well do that. Or we have to be prepared for the possibility that the Council does that. What does that mean? Increasingly, we have a perception that the International Criminal Court is in some ways de facto some sort of subsidiary organ of the Security Council. Most people see the prosecutor, if at all, if he comes to New York to brief the Security Council on his work on Darfur, because that is an investigation that the Council commissioned, mandated. So it's a situation that was referred to the ICC by the Security Council, contrary to the other two. If the Council is to adopt an Article 16 resolution, that means if it decides to suspend investigations and prosecutions for at least 12 months, at least that's what Article 16 says, so let's say 12 months, that impression, of course, will become stronger. And people will think, in essence, a lot of people will think, in essence, the court is a tool of the Security Council. And that, of course, is a significant political problem for the credibility of the court as an independent criminal court, the way we all conceived it in Rome. If I say that the Council well may do it, I'm saying that because that's a reality Let's say that's a fact of realpolitik. So we all know we cannot stand here and say this is impossible, the Council will never do that. We all know it is a possibility. If the Council does that, I think it is very difficult to argue why it is doing that. It would mean that the Council first initiates an investigation and a prosecution into a situation in Resolution 1593, so sends that situation to the court itself, and then some 2.5 years later decides to suspend investigations and prosecutions. Why? How can you explain that? I think there's only two ways of explaining it. Either you're saying that the situation in Darfur is not as serious as it was when the Council first referred the situation to Darfur. And I don't think this is what the Council wants to say at all. Or you are saying, in essence, that you believe that the indictment that the prosecutor is seeking against the president of Sudan is not helpful, perhaps not justified, or certainly not helpful. And that would anyway be the perception, because we all know the discussions on the role of the ICC in Darfur before July and post-July is very different. So we all know that this is the real reason. And that, of course, is politically and legally very difficult to argue simply in light of the fact that the statute explicitly says otherwise. So the statute explicitly says that official capacity, it even says in particular, as head of state or head of government, is irrelevant for the purposes of investigation and prosecution. So for states parties, this will be a very difficult sell. I'm saying that because I think this really is the main element in the big political picture that we have right now. And the work we're doing on aggression has something to do with the Security Council. We have made, in fact, progress on the role of the Security Council that is not usually mentioned, but that is very important, namely that most states now agree that the first shot at their determination should go to the Security Council, while there were many in Rome that said the council should have no role at all. So this relationship, Council, ICC, I think is a decisive factor for the future of the court, and this is what we should keep in mind when we talk about aggression at the review conference. Thank you.
We have time for some questions, and I think someone's going around with the microphone, I assume. So if you just put your hand up and wait for the microphone to come to you.
No question?
There are questions. There's always.
Ambassador, you spoke a little bit already about requests that have been made or suggestions that have been made by both states parties and non-states parties. Can you talk about how much role non-states parties do have and will have in the definition of aggression, or whether or not it is defined in this round?
How much of a role they do have? Well, we have a lot of states parties that come very regularly to the meetings of the special working group. That means states that do not otherwise participate in the work of the assembly. They're treated the same way that other states are treated, and some of them make useful contributions. The United States is not among them. Unfortunately, they do not come to our meetings, even though that would be very helpful. But there are a lot of states parties that contribute. Non-states parties, sorry.
Thank you. Ambassador, concerning the last part of your presentation, the relationship between the court and the Security Council, I'm curious to know, you mentioned that the tendency is to say that the Security Council will have the first shot at it, at establishing aggression. Now, in the discussions, has it been discussed whether that would mean a predetermination for the court, and the court should abide by that determination of the council that there is an act of aggression and simply concentrate on individual criminal responsibility? Or would the court be entitled to review that, the legality or the legal characterization of the council's determination of aggression and decide in the end there is no act of aggression?
Well, I think what is agreed is, first of all, the structure, that in order to have the crime of aggression, you need a state act of aggression. So no crime without the act. That's one thing. The other thing that is agreed is that in accordance with Article 39 of the UN Charter, the first instance to make that determination is the Security Council. That is pretty much okay with everybody now. What is not clear is what happens if the Council does not do that. Does that answer your question?
Well, what happens if the council says there is an act of aggression,
right,
and the court disagrees?
Right. Yes. No. That's the part I did not answer. No, we did. That is not. That we are certainly not discussing that, and I think that's also where the principle of best interest of the court comes into play. Yes.
What countries provide the greatest support for adoption of the definition of aggression? What group of countries, or who are the leaders?
Well, that's in some ways not a good not a good question for me to answer.
The regions.
No, this is not a regional. This is not a
Not
regional
the
issue.
individual on a state by
Yes.
state.
Yes. Yeah. Yeah.
Mr. Ambassador, in your comments, you didn't mention the possibility of the General Assembly or the International Court being one of the triggers here, and I'm wondering if that's just because you had limited time, or whether there's now a sense that those possible trigger mechanisms are falling away.
They're still there as possibilities if you have read the latest discussion paper. Politically they do not get that much support. So they are there because some people think they would be alternatives, but there is not, let's say, there is not at this time anyway, a very strong push to agree on one or the other. What we're really looking for is sort of a third way.
Earlier today, one of the speakers had pointed to the relative lack of activity by human rights NGOs, mentioning specifically Amnesty International, Human Rights Watch, and the International Federation of Human Rights. Have they truly been absent, even on the sidelines, from providing at least information to states parties or potentially interested states on what is your impression, to the extent that you're aware of any activity or lack thereof by such groups?
No, NGOs are present, and some of them are here, and NGOs have made very important contributions. I respect if an NGO says this is not our competence, this is not what we do, so we don't have a position on that. It is also certainly true that on this issue more than on others, NGOs tend to disagree among themselves. So they would not be able to come out as the unified force on this particular topic as they did in Rome on a number of topics, on the role of the Security Council, on the ex officio power of the prosecutor and so on. But NGOs are, in all fairness, they are present, and they actually make very good contributions. Some of them have the official policy that they don't have a position. Yes. Ben.
Thank you, Mr. Ambassador. Is there any suggestion or recommendation that you can make for the NGO community to help get aggression accepted within the jurisdiction of the court?
Well, I think, creative thinking is great, and keep thinking on possibilities for compromise on the role of Security Council, and of course whatever influence you can have among states parties, if you can use that to that effect, that is also immensely helpful.
Would that be desirable in light of what your comment was, that some people think you should just forget about it? What would be the impact on the step forward by Nuremberg? I put this question to one of the other speakers. Would the failure to follow up on the Nuremberg definition and conclusion, would that be a step forward or a step backward in your view in the development of international criminal law?
Well, I think it's very difficult to argue that it's a step forward, isn't it?
Ambassador, can I ask you about the other crimes, terrorism, drug trafficking, which are also sort of lurking somewhere with the potential to be on the agenda and to be discussed? I think they have to be. In theory, they're on the agenda at the review conference. Is anything going to happen there? Is there any sign of it? And there's one other piece that's not formally for the review conference, but it could be, which is the famous annex on prohibited weapons. Is anything going to happen on that?
On the crimes, I don't see much right now. I can tell you it's a very personal assessment. There's nothing to do with any function that I may have. My expectation is if we have an agreement on a comprehensive convention on terrorism in the General Assembly, including that famous definition, then there might be a serious effort to include that in the statute, and not even then it is a given. In the absence of such a definition, I think this will be a completely marginal topic. That's how it looks to me now. On the drug issue, that's I think even more the case. I mean, this was traditionally pushed by a specific number of states, and I have not seen any indication from them that they will put that forward. Same on the annex.
Thank
Okay.
you very much.
Thank you.
Well, we are now back on schedule. So why don't you everybody take the 20-minute break now, and we will start promptly at 2:15 for our next panel.